Wonderful. Our next award is the Public Service Award, and Terry Truewiler will present that. It's an honor to present this year's Public Service Award. Trial Lawyers Association to retired Justice James C. Nelson. I'm sure our special guests will appreciate this. To our great disappointment, and to Sherry Nelson's great relief, Jim's retirement at the beginning of this year brought to conclusion what I think most informed lawyers in the state of Montana will long remember as the Nelson era of the Montana Supreme Court. And I can tell you that Jim's intellect, his incredible work ethic, his sense of fairness and justice, his commitment to the Constitution, and his commitment to fair treatment for those people who rarely get fair treatment in the other two branches of government is going to be sorely missed. We're not here though to bury Jim, we're here to praise Jim for his contributions to a living state constitution, for his commitment to individual rights, and for the well-reasoned contributions he made to the common law over the past 20 years. If you're a lawyer in my generation, you have known many permutations of the Montana Supreme Court. It changes. But you'll remember Jim for his bedrock reason, his consistency, and his intellectual vigor over a longer period of time than any individual has ever contributed those qualities to the court. If you're a younger lawyer who's been admitted to the practice in the past 10 years, you remember Justice Nelson for the long opinions that he had to study because they fundamentally analyzed and reshaped the common law for the state. So all of you study those opinions. But whether you're young or whether you're old, whether you practice for 10 years or 40 years, you'll all recognize Justice Nelson with admiration, with respect, and appreciation for his service to the state. Jim came to the Supreme Court in 1993 by appointment. He served, as I said, for 20 years until his retirement in January of 2013. During that time, by my calculation, he authored over 1,000 opinions. There were landmark decisions, many of them. They defined rights to due process, access to courts, a clean and healthy environment, equal protection, privacy, and the individual right to human dignity. Some of his opinions were dissents, in which he held the majority accountable for intellectual honesty and consistency. And we appreciated all of them. Whether they were landmark decisions or simply dissents, holding the majority accountable. I'd like to give you a few examples of some of the landmark decisions that Jim authored. In Siegel v. State, decided in 1997, Jim's opinion extended the right to privacy in Montana to include the right to be free from thermal imaging of private residences. Jim's opinion was the first such decision in the country and preceded the U.S. Supreme Court's similar decision by 4 years. And it was prescient in its advice about the threat that modern technology and sophistication presented to the individual privacy of people throughout the country. In Armstrong v. State, Jim's opinion defined Montana's constitutional right to privacy to include the right of women to choose whether to continue or terminate their pregnancies by means of lawful medical procedures. That right, therefore, in Montana at least, is enshrined as a matter of state law on independent state grounds under Article 2, Section 10 of our Constitution. In Kazan v. State in 1997, Jim wrote that state law, which criminalized sex among consenting adults of the same gender, violated our constitutional right to privacy. That was 16 years before the modern trend, which recognizes and tolerates same-sex relationships. At the time, it was a controversial decision. I remember that we argued the case over at the University of Montana Law School, and it was filmed by Court TV. That was 16 years before the age of enlightenment that we're just starting to embark on. In Walker versus State in 2003, Jim wrote that Montana's constitutional right of inviolable human dignity, along with the right to be free from unusual, cruel, and unusual punishment, prohibited the barbaric treatment, behavior modification programs that were being perpetrated in Montana state prisons. And again, in Baxter versus State in 2009, he argued that the right of human dignity was a standalone, fundamental right, and attempted to define the parameters of that right in the context of doctors who assist dying people. In McDonald versus DEQ in 2009, his opinion advanced the rights of disabled employees. And in Wright versus State in 2012, Jim wrote that the legislature's blatant effort to reshape the politics of the Montana Supreme Court by creating districts from which judges had to be elected and in which they had to reside was unconstitutional. Throughout his career, in addition to the opinions that he's authored, he helped shape cases affirming the right to a clean and healthy environment, affirming the right to equal protection under the law, consistently affirming the obligation of government entities to operate openly, affirming the right of due process in a civil justice context, which isn't that common across the country, and supporting and consistently protecting the rights of consumers and employees. In his spare time, Jim has been instrumental in bringing not just the Supreme Court, but the entire judiciary into the 21st century technologically. He alone spearheaded the effort to computerize and digitalize the Supreme Court and the district courts. He led the effort to guarantee our law clerks a living wage commensurate with their education and their contributions to the judiciary. He has spoken to countless legal organizations, civic organizations, the law school. He's written law review articles published in the Montana Law Review. He's been an adjunct professor at the law school for the last 3 years. And he's been an active participant in the efforts to improve the judiciary. I wish we had 2 public service awards. I wish we could present one to Jim and one to Sherry Nelson, because I can't imagine all the times that Jim came home from conferences at the court frustrated and angry about something that had happened that day. And I know that it was Sherry who talked him into getting back into the fray the next day. I can't tell you how much we appreciate it. But we only have one board, and I can't think of anybody who's more deserving than Justice Jim Nelson, and I know that he's going to share it with his best friend. So Jim, congratulations on the Public Service Award for 2013.
I want to just say 3 things. That's going to show. The first is the author of opinions frequently gets a lot of undeserved credit for writing an opinion, and it's really the court's opinion. I have to tell you just a little vignette about the rice increase. When the oral argument was over, the court had deliberated and decided how to decide the case. I really wanted to write that opinion. And I knew Terry would too. So I walked down to Terry's office and I said, Terry, you know, I really want to write this. And he said, well, I really want to write it too. So I said, how would I say that? And he said, well, let's flip a coin. This is honest, not true. So Terry pulled out a coin, flipped a coin, and I won. So that opinion could have been written by Terry Twain. The second thing I want to say is that I know when I was appointed to the court, there was a lot of people scratching their heads. I know that a lot of people thought, boy, this is going to be a real crapshoot. But I have to tell you that when I started practicing with Sherry's dad, Logan Leonard, in Cutbank, and we were talking one day about judges. And how some judges are good, some are not so good. And he said, you know, a mediocre judge can become a really good judge by watching good lawyers practice and by watching and reading the opinions of other really good judges. And I kind of took that to heart, and so when I was fortunate enough to be appointed to the bench, I watched closely my colleagues on the court, Terry Treebauer, Bill Hunt, later Jim McNear, Pat Potter, and I watched members of this organization and this organization champion people's rights, read the briefs that you all wrote, and a lot of what I saw, most of what I read really formed my own social conscience. So I stand before you tonight, owing all of you again for helping me be. I know that you all, as an organization, individually, supported me in my career, very tough re-election fight that I had several years ago. Watching in the authentic for help and support, how much I personally appreciate sharing this experience. Thank you. Thank you. Now, the third and final thing I want to say is simple as I am a white heterosexual man. I've never been discriminated in my life for anything. And it just simply bugs the hell out of me when I see other people being treated as I have been treated, not treated as I have been treated, and for being discriminated, for being against, for being who they are, as I have never been discriminated. Donaldson case broke my heart. I think you all know that. Absolutely applaud courageous people that stood up, sexual orientation, right to love who you want, to be who you want. I can't say enough about you. You've got more guts and more back than most people in our society. And I applaud you for that. I'm sorry that we missed the opportunity to solve the problem. We didn't. I know that you're eventually going to prevail. I want to simply close with this important experience. This last semester at the law school, I co-taught the Montana Constitutional Law class with Anthony Johnson. It was a fantastic way to write really something. The Constitutional Law class, quite to my surprise actually, was pretty conservative. In fact, there wasn't a class that I didn't get ripped up with something, which is fine. It was a pretty tough group. one thing we all agreed to a person was gay rights. And I was dumbfounded. When we studied Donaldson and Rice in some of those cases, one thing that they all agreed upon was gay rights. And I just kind of said a silent thank you that at least this generation is moving ahead with bigotry, fairness, and discrimination past generations have opposed to LGBT. So you are going to win, you are going to prevail. Hang on. Again,